Good morning, and may it please the court. My name is Matthew Guido, and I represent Mast Capital Inc. I would like to reserve 2 minutes for rebuttal, if that would be okay. The issue in this case is whether the trial court correctly entered final judgment in favor of Whitehall Realty against Mast Capital, finding that it was the procuring cause of a transaction occurring on a property in Key West, Florida. It is our position that the trial court's application of the law to the facts that were presented at the bench trial improperly expanded the right of a broker to receive a commission, really to every situation where a broker becomes involved for a very short time with the property and then really has no further involvement after this really short window of time.
And I think that's our standard of review of a trial court's findings on credibility of witnesses.
Yes.
I mean, here the trial court, I think the word was incredulous.
That's correct.
That your client didn't remember the prior involvement.
That is exactly what the trial court said. And now,
How do we address that when the trial court makes a credibility finding like that?
I have 2 responses to that, Your Honor. First of all, at the motion for new trial, the issue of whether he believed or did not believe Mast Capital was raised to the trial court, and the judge said that did not come into his mind in actually making his final determination. He rested his decision on the fact that, and I'll quote, the court found procurement based upon the fact that through the evidence it was shown that the initial party showing the property and discussing it was the party who procured the sale. So in effect, what we're really asking for on the standard of review is that we believe that the trial court improperly applied the law to the facts, even looking at those facts favorably to Whitehall, which I believe the court would have to do because it's obviously...
But just to follow up on Judge Lindsay's question, whether it happened by happenstance, I think is the term that you used.
Yes.
Whether it happened by happenstance or whether there was an abandonment, aren't those both classic factual questions?
It could be fact questions, but in this record, those are essentially undisputed facts, especially with the happenstance issue, Your Honor. And the happenstance term comes from the Edwards case, which is obviously the case where we rely on most heavily. And in the Edwards case, that was actually a reversal of the summary judgment where the second district entered judgment in favor of the seller in that case, based upon the record. And what we have in the facts of this case, even putting aside whether Mast Capital remembered or did not remember, because in our view, it's irrelevant whether they remembered or not, based upon the facts that were introduced into the record, essentially undisputed. And what we know is that after June of 2013, there was no further communication at all between the Whitehall and the seller, or Whitehall and the buyer. There was not a single communication after between June until December. So the happenstance issue comes up because the way that Mast Capital became involved once again in this property was because of its associates' work on another property in Delray Beach. And actually in the supplemental record 208, there's an email that Ms. Resnick sends to Richard Swartz, who she was working on with that property, simply asking if they'd be interested in selling a different property at that point in time. So the break in the time period where between June and December of 2013, where there are no continuous negotiations, that in effect precludes Whitehall from receiving a commission in that circumstance.
These are your clients are very sophisticated real estate acquisition folks, right?
I can't deny that,
Yeah.
Absolutely.
It's a compliment. But,
I know.
but the conduct here is also consistent with the view that because there's an LOI and because people keep files and because we're talking about the same property, all of those facts are consistent with exclusion, aren't they? To say, gee whiz, why should we have this troublesome broker that we dealt with on the first transaction? Why shouldn't we exclude him?
I do not think the facts show exclusion, and I'll tell you why.
Does the principal of Mast and the group have to approve the transaction?
I would say
The
yes.
ultimate transaction?
Absolutely. But the reason that there's no exclusion in this case, and it takes away from the exclusion cases, is again because of the fact that the negotiations absolutely ceased in June of 2013. And we cited in our case our brief for the Darracott case. And this is back in Florida Supreme Court from 1955. And it says where a broker has failed to effect a sale and negotiations have ceased or been broken off, the owner may take up negotiations where they were left off and himself complete the sale. And the mere fact that the sale may in some degree have been aided by the previous efforts of the broker is not in and of itself entitled to a ladder to
Now,
a commission.
what's the exception to that Justice Cantero spelled out in Rotimi?
Well, the exception is always going to be whether there's exclusion. And to show exclusion, or actually all the exclusion cases really deal with a situation where there's a buyer or a seller, and they have a direct negotiation excluding the broker.
Here, factually, the testimony was that your client said, no, I'm not going to raise any higher than that letter of intent.
He said that, yes.
So then what would be the point of the folks at Whitehall continuing to try to work the deal if he said, that's my bottom line, I'm not paying any more, and they've been told, on the other side, we're not accepting that. I mean, where does it go from there? And then your client ultimately does then make a higher offer.
He sure does. And in the testimony where he says, I'm not going to raise it anymore, what he did also testify is that did not mean I wanted to stop negotiating at that point. Because what we had is about $1.5 million spread between the buyer and the seller at that point. On a $34.5 million offer. So this, talking about a lot of money here. It's not a huge difference when you're talking in the grand scheme of things. And also what Mr. Mariloff said is typically when you have a spread of that size, you're going to still try to bring the buyer and the seller together at that point. He did not do that. That is what Mr. Miguel said he expected would happen in that situation. But it did not. And that's why the negotiations broke off at that point. So just because he is the first person, meaning Whitehall, to introduce this property to Mast Capital is not automatically entitled to a commission. And that is exactly what the Siegel versus Landquist case said. The only exception, again, being exclusion. And to show exclusion, again, I think looking at the Sheldon Green case in particular, because that's out of this court, and certainly that's what...
Understanding that your theory of the case is there was no exclusion, the Whitehall folks just sort of dropped off, once Mr. Miguel said they're not going to pay higher than what we offered already. Then the testimony was that we forgot about them.
That's right.
So not that we were excluding them, but we forgot about that letter of intent. We forgot about having dealt with them, what have you. And then that's where the trial court came in and said, I find this incredulous.
And what I submit to Your Honor is whether they remembered about Whitehall or not, under the case law or under the law about procuring costs, it really would not make a difference if they remembered. Let's say in December of 2013, Mr. Miguel said, oh, I remember I had looked at this property 6 months earlier. I don't think that would change the analysis because of the fact that everything broke off in June. And we cited in our brief to the West Ship World Yachts case out of this court from 2007. And again, going back to the common thread in these exclusion cases, the commonality in all those cases is the broker who is seeking the commission essentially played a large part in allowing that property to be transferred or sold. And without that broker's involvement, the transaction would not have occurred. But what Westworld also tells us is if it would have happened regardless of the conduct of the broker, then there cannot be a procuring cause in that scenario. And what we have in this case is the facts, I think, are essentially unrebutted, that this transaction would not have occurred if Mr. Schwartz and Ms. Resnick had not worked on the property in Delray Beach, which Whitehall had no involvement in whatsoever. Whitehall's involvement in this case in June 2013, in our view, played absolutely no role whatsoever in allowing this transaction to occur.
Remind me again, how does the two of them working on Delray Beach property relate to this?
Okay, so Ms. Resnick, through an associate that she
From Philadelphia.
From Philadelphia, was introduced to this gentleman, Mr. Richard Schwartz, and they were looking at a property in Delray Beach. After they did some due diligence on that, Ms. Resnick did some due diligence with Mr. Schwartz on that property, a deal was not struck. So Ms. Resnick, the testimony is, she looked on the seller's website, just seeing what else this seller had to offer, and came across the same property in Key West. She then sent an email to Mr. Schwartz and said, and the email, all it says is, West Isle Club, this one could be interesting, would they be open to selling it? Mr. Schwartz responded, yes. And that's where all the due diligence occurred after this date of December 16th, 2013. This is when all the rent rolls were passed back and forth for the next couple of months, and the PSAs were ultimately drafted, amended a couple times, and the closing occurred in 2000.
You're just about out of time, but you raised a second point, of course, in your brief as
Yes,
well. Birchfield v. Realty Execs was filed on Friday as additional authority. It's a 2007 case, but
Yes.
I suspect that kind of a late filed reply brief with extensions of time and everything, and a response to it here puts us up against the mark. But I wanted to give you a second to give us your reaction to Birchfield Realty execs on the question of transaction brokers.
Sure, and what my reading of Birchfield is that it certainly limited the fiduciary duties that a broker would have to a buyer or seller within the context of the statute. But the fiduciary duties that are actually outlined in the statute itself include a couple of things, like dealing honestly and fairly, disclosing all known facts that materially affect the values of residential, that's actually residential, I apologize, but dealing honestly and fairly, let's say. But what the statute does not say is that it overrides the common law aspect of having to tell a buyer and a seller, or having them agree that the broker could be on both sides of the transaction.
All right, so you're sticking to your
I am. I don't think that case takes away the common law in that respect.
Okay.
And we respectfully request that the final judgment be reversed and in favor of what?
All right,
I'm
you
sorry.
have a little bit of
Thank you.
Thanks.
Good morning, Your Honors. May it please the court, I am Peter Meltzer from Path & Lewis, representing the appellee. With me today is the appellee's president, Devin Marinoff. Your Honor, the Florida Supreme Court in the Rotendi case has set forth a two-part test to determine when a broker earns a commission. The first prong of that two-part test is bringing the buyer and seller together. The second part is staying involved in the negotiations unless the broker is excluded from those negotiations. The trial court found that my client earned the commission because it satisfied both of those prongs. And as Rotendi provides, the factual findings that the trial court made cannot be disturbed unless there is no competent substantial evidence to support that. It is undisputed that my client brought the parties together by introducing the buyer and the seller. The Mast admitted at trial that at the time my client submitted the letter of intent to the seller, Whitehall was the first and only broker at the time to ever do that. So it is undisputed that the parties, that my client brought the parties together. The first prong is satisfied. As far as the second prong goes,
exclusion and temporal break, I think that's what you need to address.
Correct. And the trial court ruled on the overwhelming amount of evidence produced at trial that showed exclusion.
And that's fact-intensive in any event, right? That's a fact-intensive determination for the trier of fact, not for this court, assuming competent substantial evidence.
That's absolutely agree. Absolutely.
So it really comes down to what has been characterized by the appellant as a break-off in negotiations.
Correct. As Your Honor pointed out earlier, from the get-go, once the seller rejected the letter of intent, the defendant's president testified at trial unequivocally. He said, no, I'm not raising my price a penny. And you know, that's evidence of exclusion right there, which relieves my client from, I don't know if the appellant wanted my client to continue to pester him or what, but.
Assuming his argument that your client should have said, oh, you know, call him back in a week. How about if you go up, you know, 200,000, you know, let's try that, you know, let's keep it going. I mean, should he have done that?
Well, he didn't have to under the law, so the answer is no. He did continue to work the deal. The record shows that Whitehall did contact the seller after that rejection to see if the seller would reduce his price. So there is no evidence of that, period. Also, I'd like to point out that as further evidence of exclusion, at trial, everyone who testified from the defendant or on the defendant's behalf seemed to have this amnesia that they never remembered my client submitted a $34 million letter of intent on Mast's behalf just months prior before they started renegotiating behind Whitehall's back. And what made this so unusual, and what made trial court judge find it incredulous, is that at the time my client submitted the $34 million letter of intent, it was one of the largest deals that Mast was working on. It was one of the few, if the only, in Key West at the time he was working on. The defendant testified that there were only 3 people at the time in their acquisition team that would even be privy to the deals that Mast was submitting letters of intent on, and all of them seemed to have this complete amnesia about Whitehall's involvement, which the court found with prejudice. I also want to point out, I want to address the argument as to Sheldon Green that opposing counsel addressed in appellant's brief. He seems to be making a distinction that his client was justified his client can escape liability for the commission because he negotiated, because he hired another broker. Well, I'm sorry, Mr. Swartz is an unlicensed broker, but he seems to be making a distinction between working with another broker or party or going directly to the owner to negotiate the sale. And I want to be clear on this. Sheldon Green, the purpose of Sheldon Green and most of the broker case law is designed to protect a broker who facilitates a transaction, brings the parties together, and is then excluded. It does, according to Sheldon, it doesn't matter whether Mast hired Mr. Swartz to get the deal done or go directly to the owner. Sheldon makes it very clear that all the broker has to do to earn the commission is to establish that it was dealt out.
Right, the question isn't, did the appellant pay somebody a commission? The question is, was the appellee entitled to a commission? Now, there may be evidentiary significance to the fact that the appellant went and hired another broker, right? It may go to the question of intent to exclude or whatever, right? Because theoretically, he exposes himself to having to pay a commission twice.
Absolutely.
But as a matter of law, it doesn't matter whether he ultimately paid a commission, but to somebody else. It's a question of whether the appellee received a commission and whether he was entitled to receive.
That's what the case law says. That's what Rotemi, Florida Supreme Court, does not put these qualifications on the two-part test. If you take opposing counsel's interpretation of Sheldon Green, which is a binding third DCA case, all a buyer would have to do to escape liability from a commission is just hire a friend or another broker. It doesn't make sense, is real.
Well, their position is that, their clients forgot about your client and that they had no intent to deal him out or exclude him because they were working with another broker, so it's not like they're trying to avoid a commission. But then that goes back to my question to your opposing counsel about credibility findings and when a trial court makes those. Can we deserve them on appeal?
Absolutely. They should not be. And Sheldon actually addresses that point. Sheldon goes in great depth about the reason of the exclusion is irrelevant. The motive is irrelevant. Again, Sheldon has this long section about people think on broker cases when there's exclusion there has to be something conspiratorial or secret or clandestine. And Sheldon addresses that square on and says that's not the case. As long as the broker was dealt out, whether innocent or otherwise, is enough to make sure the broker earns his commission if he did bring the parties together and is then excluded.
And on your position, how long does this exposure to a brokerage fee go beyond the time negotiations are broken off?
We cite cases in our brief. The Sheldon Green case that we've been talking about, there was a 1-year gap, which is identical to our situation. I also cite the Osheroff case, which is a 14-month gap, which is even longer than ours. So the gap in time is a non-issue as far as we're concerned.
Was it a 1-year gap with some negotiations still going on, or is it a 1-year gap of crickets?
Well, in all the cases, it's after the point of exclusion. There's always going to be continued negotiations behind the excluded broker's back. The time period is from the date of exclusion to the date the buyer eventually closes. So there are cases that are there's larger gaps than in this case. And just to wrap up, I do want to address the Birchfield case and opposing counsel's argument about the dual representation. There is a Florida statute directly on point, Florida Statute 475-278, which states that the presumed relationship in Florida is that a broker represents both sides to facilitate a transaction. There's a statutory presumption to that effect. And the opposing counsel seems to think that that doesn't supplant or supersede the common law to that effect. And that's why we filed Birchfield, which I swear on states that it does replace the common law. The last page of Birchfield actually states that the trial court properly applied this principle to interpret 475-278 and properly found that failure to provide the required disclosure document does not rebut or affect the statutory presumption. So clearly that case is on all fours. It specifically discusses the statutory presumption. So opposing counsel's common law argument, we believe, has no merit. And also, just want to add, even, I argue this in our brief, even if the common law still applied, we'd still come out on the right side of that fence because the letter of intent shows that the disclosure was made. The letter of intent states that the only broker both buyer and seller were working with was Whitehall Realty. So it was out in the open. And also, just from a double standard hypocritical point, at trial, the Mast's president testified that Mr. Schwartz, the unlicensed broker that he did pay a transaction to, he knew Mr. Schwartz represented both sides, and he thought that was wrong. So based on the competent substantial evidence that supports the final judgment, we request that Your Honors affirm the judgment. Thank you.
Thank you. Rebuttal.
Briefly, Your Honor. And actually, I wanted to address something Judge Eames mentioned about whether in the other cases there were quote-unquote crickets in between the continuous negotiations.
Because that seems to be central to your argument.
That is, Your Honor.
Right?
That's exactly right. And in the cases that I've reviewed, it doesn't specifically say how much negotiation was going on between the time period of the alleged exclusion when the deal was actually struck. But what they do seem to suggest is that there is negotiation going on behind closed doors to the exclusion of the broker. And what we have here is absolute crickets between June, I would say, 17th of 2013 and December 13th of 2013. There is not a single communication that took place between Mast Capital or any of its affiliates and the seller of this property. And the unrebutted testimony in this case was they didn't even know each other. They never met, they never spoke during this small window in June 2013. And that is why...
It's 6 months.
That's 6
So you're saying, wow, it's 6 months. But if you look at it, it seems like it's 6 months.
But it's 6 months.
Are you saying that there would be a requirement that in order to prove an entitlement to their commission, they would have to prove that within that period of time, regardless of how long or short, there were some negotiations in which the plaintiff was dealt out?
I would suggest the answer would be yes, Your Honor.
A requirement.
And the reason I say that is because the continuous negotiation aspect of the Rotemi case, and actually going back to Schuler v. Allen, when they talk about continuous negotiations, that means continuous negotiations between the buyer and the prospective seller conducted by the broker, unless they're dealt out.
So if the buyer and the seller say, we're going to deal out the broker, let's wait 6 months, or let's wait 6 weeks, right? No communication for 6 weeks. We'll get together after 6 weeks. Is that enough?
I think that would be enough in certain circumstances. What we have here, again, is there was never initial communication between the two, which I think is an important factor.
Direct communication.
Right, direct communication whatsoever. They didn't even know the names of one another, essentially. They didn't have a contact to speak to. So, and going back to actually how they met in December 2013, I think is a significant factor when we look at the Edwards case. Because going back to the overall aspect of these exclusion cases, is that this transaction would not have occurred if this broker did not do something. And we know in this case that Whitehall's involvement literally had zero to do with this transaction closing. If we look at the path at which Mast Capital ultimately reached this Key West property, they were not involved, and the only reason that this transaction happened is purely because Ms. Resnick was looking at a property in Delray Beach with the assistance of a Richard.
But wasn't Ms. Resnick impeached considerably with regard to either her memory or her involvement on the front end of this property, where wasn't it established that she actually sat in on the initial meeting back in June of 2013?
And I don't think it was established. It was established that she was in a meeting, but I think actually Mr. Marinoff was impeached with his testimony that he discussed this property.
Would you say that it could not in any way be characterized as undisputed either way?
As to at that meeting whether she learned about the property?
Yeah.
I can agree with that, Your Honor.
Would a trier of fact have to make that determination?
They would have to make that
Could the
determination.
trial court have determined that in fact Ms. Resnick was present at a meeting in June of 2013 where that property was discussed?
Absolutely. they could.
And there were emails from her with regard to an interest in this type of property prior to December of 2013.
This type of property, not this property.
Understood.
Yes, absolutely, Your Honor.
All right.
But again, I think it brings us back to the, how did Mast Capital ultimately learn about this property? Again, through Delray Beach, and that's the only reason they learned of it. So we respectfully request that the final judgment be reversed. Thank you for your time.
Thank you both.
Thank you both.
All rise.